have had a great Wednesday so far. So today we are going to continue our introductory discussions about human rights. First, we will have a quick review of what we learned on Monday, as usual, and then we're going to delve into this new topic. So I just need to remind you that for these first few lectures, because I have to provide some basic introduction, our reliance on reading materials will not be as much. But starting from next week, there will be greater overlap between what I say and what you find in your reading materials. But for the last few lectures, I have tried to remain as general as possible so that we get the general framework right. So quick recap. What did we discuss on Monday? What did we learn? Yes, Joshua.
We were talking about the relation between human rights law and international humanitarian law,
The difference between international human rights law and international humanitarian law.
How IHL has to do more with wartime and focus on what combatants can and can't do during wartime, and human rights law focuses on basically it's a general rule, so it's not applicable during wartime. It's applicable during all times.
That's right. And still, when there is a conflict of norms, the tool introduced by the ICJ is lex specialis, which says that when there is a conflict of norms about a subject matter, the legal regime that is more specific and related to that subject matter will govern the conflict. And that's the rule of lex specialis. What else did we take on Monday? Yes.
We also talked about the two main principles of international humanitarian law, the principle of distinction and proportionality.
Principle of distinction and proportionality when questions of targeting are raised in international humanitarian law. We said that the general rule is that IHL permits targeting combatants at all times, but forbids civilian casualties, though we also became familiar that we have this concept of collateral damage, which means that to the extent that a military operation has been proportionate and has observed the principle of distinction, civilian lives may be taken, though with the restrictions that I just mentioned. And this basically creates some differences between how human rights law governs an issue and how IHL views a given right. What else? Yes, Will. Yes, go ahead.
Talking about the different sources of international law and how common law versus civil law traditions kind of have a divide here, and then the intricacies of how common law versus civil law actually worked and what they prioritize.
That's right. So we learned that when Article 38 of the ICJ statute mentions legal principles, general principles of law as recognized by civilized nations, we now interpret that problematic phrase, civilized nations, to mean the two major systems of law or the different systems of law, though, as we learned, most of these different systems can be classified under one of these two broad categories. What else?
We also focus on lex lata and lex ferenda and how it pertains to hard law and soft law.
That's right. So we actually examine these distinction between hard law and soft law. Hard law meaning binding law, enforceable law, and soft law meaning laws that are not enforceable as such, but they are definitely in the process of being formulated as hard law. So soft law is more of a progressive concept, and hard law is more realistic, which goes down to this difference between lex lata and lex ferenda. Lex lata means the law as it is, and lex ferenda basically refers to a more ambitious conception of law. Great, thanks. There was someone here who wanted to give us some. Yes.
I was just going to say the same thing, but I can add on to say it.
Sure.
For hard law, it would be something, for example, like UN Security Council resolutions versus something for soft law. Could be an example of like UN General Assembly.
That's right. So General Assembly resolutions usually fall under the category of soft law, and Security Council resolutions usually identify and epitomize hard law. But we saw that even within the realm of the Security Council resolutions, we make a distinction between Chapter 6 resolutions and Chapter 7 resolutions, with states having a unanimous view that Chapter 7 resolutions are binding, definitely mandatory, but Chapter 6 resolutions are a bit more on the side of soft law, but again, as I said, states are divided on how they interpret Chapter 6 resolutions. Cool, that's some of what we learned on Monday, and today we want to consider some other topics that directly speak to what we learned on Monday. But let's start with a question, and this question basically sheds light on what we are about to discuss. So this is actually a very famous thought experiment in international law and also domestic law. And the thought experiment goes like, imagine you are a police officer or you are a security official, like the director of an intelligence office or ministry, and you have a terrorist suspect at your custody, and this terrorist suspect knows exactly where a ticking bomb is located, but he refuses to disclose the location of the ticking bomb. Is it permissible for you to perhaps torture this terrorist suspect when there is no other way to obtain information from him? So what are your takes on that? So if we can use physical coercion to extract information, or torture to get information that you like from this suspect. Yes?
I think about lex specialis, like how we learned that sometimes in general law, sometimes you have to specify. Maybe even if it is a violation of human rights, if I know that bomb is going to affect the lives of more people, then I think I would have to do something.
So you think that it could be permissible provided that the legal framework provides for such a possibility, like the rule of lex specialis says that using physical coercion or coercive interrogative methods may be permissible in this situation. Okay, not bad. Thanks.
To answer that question, a question I would ask before that is this during wartime or is this just like civilian, like out in Canada right now?
Does it make a difference in the outcome, you think?
We can use international humanitarian law, right? And that would be, I think that would be used to not kill the civilian, but I would torturing the civilian would be more permissive.
Cool. Even though torture may be painful than death, but still, you keep the guy alive.
I would also consider a principle of proportionality. I guess I know it's also maybe part of international humanitarian law, but maybe in this situation that would make sense to torture one individual because I guess the benefit would outweigh the cost.
Cool. So your view is that we can use torture and apply the principle of proportionality. We use torture to the extent proportionate to our aim, that is to extract information from this person. That's a very imaginative argument. What about a scenario in which we don't have to use physical coercion, but we can use practices that border on torture, but are not really torture as undertaken or committed by us. So for example, one very common method that intelligence services use sometimes, and this was very common, was to give torture pills to the inmates. So basically they take a pill and then they go to sleep for 2 hours or for a limited period of time. But that sleep is filled with dreams that are torturous, and the person goes through excruciating pain as they are sleeping. So this way, the officer tasked with interrogation wouldn't feel that bad about the process and would protect the mental health of the torturing officer. Does that make a difference?
How does the concept of innocent until proven guilty enter in this method of having to gather evidence? When is someone already incarcerated? I'm guessing they're probably in the process of being tried as guilty or not guilty. So how does it work?
That's a great question. But, well, the principle of innocent before proven guilty is a fundamental principle of law. But here you are facing a scenario in which you have a suspect, not an accused. So you are not using the criminal justice system to get to what you want. You are going through a very different process that really doesn't take the principle of innocent before proven guilty very seriously, because they have to act on suspicion. But that's also another very relevant issue that comes up usually in discussions around interrogative methods and how we are going to treat suspects in general. Okay. Yes.
I wonder if you could say that a suspect has forfeited their human rights because they pose a threat / have taken away from others, in the same way you would detain a murderer.
That's a very deep argument, sometimes presented by jurists and philosophers in favor of taking a more permissive approach. So basically they say that, the principle of innocent before proven guilty is designed for individuals, regular criminals who commit regular crimes. But individuals who do not believe in the process of law, who are acting against the system, are somehow exempt from those principles. You may think that that's discriminatory, but sometimes that has been used as an argument, though you may not agree with it, but that's definitely an argument. All right, so the reason for mentioning this scenario is twofold. First of all, we want to understand a bit about the philosophy of rights, and then we want to see how this relates to the legal structure. As regards the philosophical question when it comes to human rights, it's been argued by philosophers such as John Rawls that rights are trump cards. So what do we mean by trump cards? Is that these are privileges that individuals hold against the society. And the society cannot forfeit them so easily. So if your right to freedom of speech is taken from you, you have the right to contest that. A state cannot forbid you from, for example, speaking to the press, or the university cannot forbid you from speaking your mind in the classroom, because you have a right and your right is recognized. Okay? But then there is this very complicated argument. And the argument basically goes as far as saying that, well, what if there is some utilitarian advantage in removing or suspending some rights? So, and what is the interest of the public? So, for example, if a certain individual is using his alleged human rights to endanger the public safety of the society, definitely it would be wrong for you to say that the society cannot take countermeasures in order to protect a greater interest. And so there is this trade-off in human rights, sometimes between individual rights and collective rights, or individual interests and collective interests. But does that mean that we accept the argument that human rights are not absolute? So here we need to make a distinction. Some human rights are absolute, and some human rights are so fundamental that they cannot be waived at any time. So, for example, the right to be free from torture is a fundamental right. Nobody can be subjected to torture, even during the most pressing emergencies. Even IHL does not provide for that possibility, because the right to be free from torture is a fundamental, inalienable right. So, another way to characterize fundamental rights is by referring to them as inalienable. And the reason is that these rights cannot be suspended at any point. You cannot be alienated from these rights. So these rights are inalienable. So the right to be free from torture is one. The right to be free from arbitrary deprivation of life is another fundamental right. The right to fair trial is a fundamental right with some limitations. So let's go through these issue of where restrictions are permitted and so how some rights may be limited in certain situations. So as I said, limitations sometimes are necessary to strike a balance. And the balance trade-off is a common rhetoric in international human rights law. And the first place where some rights may be limited is when states enter reservations into the treaties they sign or ratify. So international law is a consent-based system of law. States are bound by consent. It's very different from domestic law. as a citizen, even as a committed citizen, you don't have an option when it comes to certain obligations. But the states do have that option, and because it's a system that works on the basis of a state's consent, it needs to encourage the states as much as possible to ratify treaties. And that means that sometimes we make concessions in international law. And one place where these concessions become relevant is the permissibility of reservations for treaties. So what does this mean? Reservation is a unilateral statement that the states make when acceding, signing, or ratifying a treaty. And basically, states say, as they often do, that we want to ratify this treaty with the exception of this particular provision. So states, in effect, say that we accept to enforce this treaty except for this provision. We don't like this provision. We want to be exempted from this provision. And that becomes, in effect, a reservation to that treaty. So this is an acceptable practice in international law. But there is a limitation. The limitation is that states which enter a reservation cannot do so in a manner that is in violation of the object and purpose of that treaty. So a reservation cannot be in violation of a treaty's object and purpose. In other words, if a state enters a reservation that violates the object and purpose of the treaty, that reservation is not valid. Yes? Yes, almost all multilateral treaties in international law, almost all of them, with some very few exceptions, permit states to enter reservations, okay? And so, for example, there are some controversial examples, there are also some not so controversial examples. Let me start with controversial examples. So, for example, Saudi Arabia, when ratifying Convention on the Rights of Child, entered a reservation saying that we implement this convention only to the extent compatible with Islamic Sharia law, right? On the surface, this looks good and probably not problematic, but there is a great tension here. Why? Because in Sharia law, adulthood is considered to be between 9 years old to 11 years old for females and about 13 years old to 15 years old for males, okay? But under the Convention on the Rights of Child, reservation, on the Convention on the Rights of Child, adulthood basically starts at the age of 18. Below the age of 18, a person is considered a minor. Okay? So this has far-reaching implications. For example, for the practice of child marriage. Convention on the Rights of Child prohibits child marriage. But the practice in Saudi Arabia, between the age of 9 to 18 years old for females, marriage used to be permitted. Saudi Arabia changed its laws. Now that's not the case in Saudi Arabia. But here you have a reservation that is clearly in contradiction with the object and purpose of the treaty. Okay, so that's a controversial example. Saudi Arabia, by the way, was not alone in entering that reservation. I think Pakistan and the Islamic Republic in Iran, they also entered a similar reservation. And this was again very consequential because, for example, for death penalty and criminal responsibility, minors committing a murder below the age of 18 were executed in some of these countries by the claim that these were not minors. And you see a very stark conflict here between the domestic law, international law, somehow intended to be reconciled with a reservation, but really the reservation was in violation of the object and purpose of the treaty. How do you understand what the object and purpose of a treaty is? Usually, objects and purposes of treaties are mentioned in the preamble to conventions. So usually in the preamble section of treaties, you have a phrase or two about what the true purposes of the convention are. You had a question there?
I just wanted to know how that would work, right? The direct contradiction. Like, first I wanted to know how they still entered it, if it's not really permissible, like if it went against what the treaty was, how were they able to enter it? And that means that they were removed from any consequences, so they didn't face any?
Well, that's a great question. Usually these treaties, multilateral treaties, especially those that have been adopted by the UN bodies, they have a treaty body. So a treaty body is basically an organization, a judicial or quasi-judicial committee that supervises the implementation of a treaty. And usually what these treaty bodies do, so for example, for the Convention on the Rights of Child, we have the Committee on the Rights of Child. And what the Committee on the Rights of Child does is to issue periodic reports on the performance of state parties to the treaty. So usually those states get some sort of they receive criticisms from the treaty bodies for their reservations. And if they take those criticisms seriously, they usually withdraw their reservation. So Saudi Arabia withdrew its reservation after the committee criticized Saudi Arabia on multiple occasions. But the Islamic Republic, for example, never withdrew its reservation, and still a major problem. So yeah, that's how it works for human rights treaties. But sometimes it's argued that the very purpose of human rights treaties does not contemplate the possibility of reservations. So there have been jurists suggesting that the very philosophy and rationale behind human rights law is that it wants to protect individuals, and states unilaterally enter reservations that violate individual laws. Really, the practice of entering reservations for human rights treaties goes against the very spirit of human rights law treaties. But still, that's a common practice. Many states enter reservations, especially for international human rights treaties. Regional human rights treaties, as it were, can be a bit different. So there's also a more technical aspect to this. When states enter a reservation, some other parties, state parties to that treaty, may find that reservation objectionable. And usually what states do in these situations, if they find a reservation not very ideal, they object to that reservation. And when they do object to a reservation entered by another state party, two legal possibilities can be effectuated. The first one is that a state objects to another state's reservation, and therefore the part that the state wanted to reserve becomes invalid. So when a state objects to another state's reservation, sometimes the reservation becomes invalid in the relationship between these two states. But if the objecting state finds the reservation in violation of the object and purpose of that treaty, the treaty as a whole becomes invalid as far as the relationship between these two states go. So an objecting state has two options. First, object to another party's reservation, but keep the entire treaty except for the reserved section valid in between them. But if another party objects to this and says that, well, the reservation is in violation of the treaty as a whole, then the entire treaty becomes invalid between these two states. Yes.
So in the case of a multilateral treaty, though, let's say there's like state A and state B are in conflict over a reservation, but there are 5 other states involved, the treaty still stands for those 5 other states not involved.
Correct. So this does not affect the relationship of the state entering a reservation with other states. It only becomes relevant to the relationship between these two states. So this is also very common, especially Scandinavian countries. They usually object to reservations entered by other states in human rights law treaties. I know that the US entered a reservation when ratifying the ICCPR, International Covenant for Civil and Political Rights, and several other states objected to that reservation, and therefore the reservation bit became invalid in relationship between the objecting states and the United States. It's very, very common in international law for states to object to another state's reservation. In human rights law treaties, they may not want their nationals to be affected by the reservation that has been entered by the reserving party, or they just view that as an unfavorable development. They don't want that reservation to take effect to begin with.
Yeah, and then is there ever any litigation at the international court between the two states, or the state objecting and the state viewing the reservation? Or is it always the outcome is that the relationship is soured between those, not soured, but the treaty in part or in whole is then made invalid? Like there's never, is there any opportunity for the state who is being objected against to like make a case for themselves and then argue in favor?
Litigation in international law going to International Court of Justice or an arbitral commission or any other forum for conflict resolution is usually the measure of last resort. So many of those disputes do not find their way into International Court of Justice. But we have a famous case in International Court of Justice, its first advisory opinion, I think, after the Second World War. This is called ICJ Advisory Opinion on the Convention on Genocide. And basically what happened was that some states like India, China, and the United States wanted to ratify the Convention on the Prohibition of Torture. But in effect, what they were saying was that they wanted to enter a reservation giving immunity to their nationals if they were ever charged with genocide accusations. And the UN General Assembly submitted this question to the ICJ asking if reservation as a general rule is permissible. And it was the International Court of Justice that for the first time said that reservations are possible in such cases. And the Vienna Convention on the Law of Treaties, VCLT 1969, it used the exact framing of International Court of Justice to specify reservation rules in that treaty. So we've got cases like that, but we also have cases in human rights law between individuals and states, and I'm going to mention some of those later. But here you see a tension, rather, between human rights law and international law. The reason is that international law as a system is built on reciprocity amongst states. And that's why it permits entering reservations, because it trusts that the reciprocal relationship between the states is going to resolve the issue. States are equally powerful and they can object to another state's reservation. Of course, what I mean by equally powerful is that they're all legally equally powerful. They all have the right to do that. But for human rights law treaties, really human rights law treaties are not a matter of reciprocal relations amongst states. Usually human rights law treaties govern the relationship between states and individuals under the jurisdiction of that state. And here is where a general rule of international law is not very compatible with the requirements of human rights law. Sometimes states also use interesting methods. Sometimes they do not issue a reservation and they choose to basically issue an interpretive declaration. So basically, this is also very common for states. When they ratify a treaty, they issue a declaration saying what their interpretation of their obligations under that treaty are. So sometimes states do not enter reservation, but issue a declaration that has the effect of reservation. In other words, sometimes instead of explicitly mentioning that this is a reservation, they issue an interpretation that very much looks like a reservation but doesn't have that title. And when that happens, interpretive declarations are treated as reservation as well. Let's see some examples as regards reservations in international law, in international human rights law. So this is a case in the European Court of Human Rights, and next week we are going to become more familiar with how the European Court of Human Rights operates. This is a case called Luizido versus Turkey, and what Turkey did when ratifying the European Convention on Human Rights as a member of Council of Europe, it said that they will not implement this treaty in Cyprus. In other words, they excluded the territories of Cyprus under the occupation or under the jurisdiction of Turkey, however you interpret Turkey's presence in Cyprus. So they excluded those occupied territories from human rights application. And the court said that this reservation is not valid. It's against the object and purpose of that treaty. So this happened through the case of Luizido. Luizido was a woman whose property had been taken by the government of Turkey, and she wanted to contest that decision, and the government did not hear her case. She took it to the European Court of Human Rights, and the government of Turkey in the European Court argued that, well, we already told you we were not going to apply the European Convention in these territories, and the European Court said, this is not a valid reservation. It's against the object and purpose of that treaty. We also have the case of Belilos. versus Switzerland. And the case of Belilos versus Switzerland is very interesting as well. Belilos is, I think, admonished by an administrative body in Switzerland. And she wants to contest that decision. Again, goes to the European Court of Human Rights, and the government of Switzerland argues that when we ratified the European Convention, we said that for the purposes of our understanding, the right to fair trial only applies to judicial bodies, and we don't consider administrative procedures for administrative bodies, like, for example, a police commission, a supervisory commission, to be governed by the right to fair trial. And the European Court of Human Rights said that this is very much a reservation because Switzerland had not initially referred to this as a reservation. That was an interpretive declaration. And the European Court said that this argument is not valid either. So reservation in human rights law treaties can become quite problematic. And it is the general view that human rights law treaties definitely are not very receptive to reservations. The Human Rights Committee, the treaty body that is responsible for monitoring human rights implementation under the International Covenant on Civil and Political Rights, has a general comment which says that reservations for ICCPR are only permissible for very exceptional cases. So that's one limitation. That's one natural limitation that the treaty law sometimes regards as permissible. What about other types of limitations? We accept here that many rights recognized under the human rights law regime may be restrained under certain circumstances. So majority of human rights are, the majority of rights are not absolute. Most human rights, in fact, can be limited. So, for example, the right to freedom of expression, very important right, but is not absolute. The right to freedom of speech, the right to freedom of religion, those rights, even though incredibly important, are not absolute. They can be restrained under certain circumstances. But usually in these cases, limitations must meet a few criteria. First of all, limitations must be necessary in those cases. And what we mean by necessary is that limitations must be reserved as measures of last resort. So if there is no other way, then limitations may be acceptable. Limitations also need to concern a public interest. So this could be public security, public order, national security, public safety, public health. And limitations must be proportionate to the purposes that they envision to realize. So you don't use a sledgehammer for a nut, okay? If there is something that requires very, mild limitations, you don't ban that right altogether. So these are instances where limitations may be acceptable. There is also another instance where limitations are usually more extensive, and that's when states derogate from certain rights. So remember the common law history and the controversies revolving the writ of habeas corpus? All those controversies would arise in situations of emergency when the king made a claim that he had a right to suspend the writ of habeas corpus. What I'm trying to say here is that suspending some rights have a very deep historical origin, at least in the common law tradition, but also in the French law, in the civil law tradition. In France, you have the notion of état de siège, which basically means that states in emergencies may act based on their discretion and suspend rights. So the practice of derogation permits states to suspend certain rights for a temporary period of time. So remember the lockdown, that was when states would, for example, derogate from certain provisions in the European Court of Human Rights or International Covenant on Civil and Political Rights that would contemplate the freedom of movement. Freedom of movement is a basic right, but it could be suspended for a temporary period of time because there was a public emergency and it was necessary for states to derogate from that provision for a limited period of time. Yes. Instances of national security threats, you have martial law, and martial laws are not usually aligned with states' obligations in peacetime. In other words, martial laws make inroads and changes into the normal obligations of states, and they contain usually provisions that are not acceptable under human rights law if they are compatible and proportionate with the aim they try to achieve and meet other conditions of the human rights law regime. Definitely there is a case for arguing that martial laws may be acceptable, but it really depends on the extent of these changes that martial laws create. So derogation is also very common, but derogations cannot concern a fundamental right. So for example, the right to be free from torture cannot be derogated by a state. Or the right to life is not derogable. The right to be free from arbitrary detention is not derogable. So non-derogable rights are another way to refer to fundamental inalienable rights. But these are pretty much exceptional. Yes, Isaac?
Is there a treaty or law that states when a state can suspend certain laws? But when you decide, when they're in a state of emergency, what is deciding whether they're actually in this state or if they're just saying they can, so they can get rid of or suspend the law?
Great question. So usually when states want to derogate from certain provisions, they communicate their intention to the treaty body or to, for example, the judicial mechanism envisioned for that treaty. So for example, it has happened in Europe. Britain has communicated derogation from certain rights in several instances. In 1990s, when fighting IRA, in 2001, after terrorist attacks in London, they communicated their intention to derogate to the European Court of Human Rights, and the European Court of Human Rights found that acceptable in cases that ensued. For International Covenant on Civil and Political Rights, you communicate that to the treaty body for the International Covenant, that is Human Rights Committee. So International Covenant on Civil and Political Rights authorizes derogation in Article 4 in situations of public emergency, and it's the state's executive usually, or the sovereign body, if it's parliament, but usually it's the executive body that declares emergency, and then they claim extensive authority in these situations. Yes?
So if Canada, for example, were to enact the Emergencies Act, they would not have to consult with all of the treaty obligations. Like, let's say if they were to take away the right or the freedom from arbitrary detention in an emergency, it's already pre-authorized that they're allowed to unilaterally declare that it's an emergency and take that right away? Or would they have to communicate with all of the bodies of the UN that are in charge of the treaties?
They have the right to derogate from derogable rights, right? So the right to be free from arbitrary detention is not derogable, okay? But many other rights are derogable. So freedom of speech, freedom of expression, those types of rights can be derogated. And as for your second question about how they are going to communicate this, you only communicate it to the treaty body, right? Not all other organs of international law or the UN. So if it's the European Convention on Human Rights, you communicate it to the European Court. If it's ICCPR, you communicate it to the Human Rights Committee. But those bodies may find your derogation not valid. So they may basically say that this derogation is not a valid one. It may concern an inalienable right, or it's not proportionate to what you're trying to achieve. Sometimes, though, this could be a big problem. For example, in Egypt, after the Yom Kippur War in 1973, I think Egypt had an emergency, a state of emergency for 40 years. So a state of emergency had not been changed by the Egyptian government, and they kind of thought that under the state of emergency, they could do whatever they saw fit. And the Human Rights Committee, every now and then in its periodic reviews, would mention that, but the Egyptian executive would not withdraw its state of emergency from the ICCPR. So some of those cases can be quite dramatic and of course not acceptable. Why? Because the purpose of derogation is to give the executive a temporary authority to deal with the emergency. And the assumption is that emergencies must be limited. They cannot go forever. So definitely an emergency behind 1 year or 2 years is very, very questionable, because usually emergencies are only for a transitional period and they shouldn't extend behind that. Yes.
Sorry, quick question. For when they so in the case of the UK, when they derogated those rights in like the 90s and 2001, they specifically they talked to the European Council for Human Rights, but what determines which treaty body you would notify? What could they have also gone to?
The treaty that you are a party to. No other treaty, right? The treaty that you are a party to. So the UK communicates that to the European Court and the Council of Europe because it's a party to the European Convention on Human Rights. Okay, but if they are not a party to a convention, then declaring, a derogation wouldn't really make that much sense for them.
Would they not communicate to for example, the UN in any capacity?
No, because the UN has a different job, right? it's the organization that overviews the implementation of that treaty. Mhm. But it's good that you asked this question. Sorry, I'll come back to you then in a second. For treaties, usually when a states ratify multilateral treaties, they deposit them in the UN treaty depository under the UN Secretariat. One of the main jobs of the UN Secretariat, headed by the UN Secretary General, is to act as a repository of treaties and keep records of that treaty in UN, in the languages used by the UN. But even then, you don't communicate your derogation to the UN Secretariat. The UN Secretariat is only there to keep the records of the treaty, not to judge how the treaties are implemented. Yes.
I was gonna ask, do they typically like consult with these parties before the derogation or after?
After derogation, when usually there is a case or dispute about that derogation. So there may never be a dispute. If there is, the European Court of Human Rights also has this administrative procedure of overviewing a state's practice, and in their reports on the state of human rights in a state party, they may mention it. So even when there is no case, they may mention that in their reports and periodic reviews. Yes.
Are these like derogation proposals strictly communicated between the states proposing it and the treaty committees, or are there cases of like other states contesting it, and then are there any legal processes?
States do not contest derogations from treaties because it really doesn't concern them that much in a situation of public emergency. And because they know that today there's a public emergency for this state, tomorrow it may be them, they don't really contest those types of practices because it's equally common for all the states, and they want to keep that freedom for themselves too when an emergency concerns them. In the disputes and in the cases. So if an individual goes and files a petition in any of these treaty rights, and we are going to see how individuals can file petitions in these different bodies next week, yes, then they can contest derogation. So if, for example, a derogation concerns detention, then an individual who's been detained may go and file a petition to one of these human rights treaty bodies or regional bodies such as the European Court of Human Rights. And we're going to deal with that next week extensively. We have the case of, as regards derogation, we have the case of Lawless against Ireland. This is the very first case adjudicated by the European Court of Human Rights, and it's about the detention of some IRI suspects. And Ireland basically keep them in detention, and they go to the European Court of Human Rights and argue that their detention is not compatible with the European Court of Human Rights obligation to be free from arbitrary detention or unlawful detention, as the European Convention calls it. And here, the European Court of Human Rights sides with Ireland, saying that derogation was a right reserved for states in states of public emergency, and therefore what Ireland did was acceptable. All right, I think we can have a quick practice here. Go to your Canvas assignment section, and there is basically there you find a list of reservations entered into different human rights bodies. Let me see if I uploaded it here. The assignment is uploaded. I'm not sure if you've got the file though. Yes. Let me see if I can upload the file here.